Hey, it seems to me, and I used to say that the two most difficult kind of cases to either prosecute or defend are self-defense cases and sex assault cases when consent is the defense in the case. And that's because it requires jurors to get into the minds of the people to decide what were they thinking at the time, as opposed to just viewing an incident on a videotape. But now I've found a whole host of cases that have been brought. There seems to be a trend now where prosecutors are bringing cases where an individual is making a claim about something that happened in the past. And a client will say, hey, that's not true. This is a false accusation. What, in your mind, makes that a difficult case to prosecute or defend?
So I think it's difficult to prosecute or defend because they're he said, she said cases, and there's no evidence to corroborate either side. The evidence is missing because at the time when it happened would have been the time to collect the evidence. So you don't have the forensics from such a rape kit. Would have been done on the victim at the time. You don't have the evidence collected by the police at the time, and which would have corroborated for the defense or corroborated the victim side of the statement. And so any evidence that would have been available at the time, say 10 years ago, is not available 10 years later. And I think that makes it an extremely difficult case to prosecute and defend on our side of the fence.
So what do you say to the client who says, there is no evidence against me?
The unfortunate thing is there is. A person saying that something happened is evidence, and in fact, juries are instructed that an alleged victim of sexual assault, their testimony is enough, if believed by the jury, to convict somebody. Their word alone can be evidence beyond a reasonable doubt.
What can be done?
So when people come to us for advice in these types of cases, we can cross-examine the police as to why, for example, there was a delay in report, or not necessarily a delay in reporting, but a delay in collecting evidence. If at the time there were things that could have been made available to the police and they didn't collect that evidence. We have had prior cases where the delay in the reporting was maybe only 10 days, but that's still a delay in reporting. And why didn't the victim go to the police? Why didn't the victim go to some other family member, report to the hospital? Was there a reason for that? And so we are able to use that to our benefit as to why they didn't do those proper things, or why was there a reason as to why they might have withheld that type of evidence, or not collected in general. Police have, in cases that we have had, not taken those proper steps to preserve that evidence. I've been falsely accused of a crime. Why shouldn't I go talk to the police and tell them my side of the story?
Sure.
And so I think that brings up another topic.
Well, and that's because the right to remain silent applies to the guilty and the innocent. You don't have to have done anything wrong to exercise your right to remain silent. You can be an eyewitness to a traffic accident or a bank robbery, and the police want to ask you questions about it, and you have the right to say, I don't want to say anything. You also have a right to say, I want an attorney with me. Sometimes that's important because I do find that sometimes clients, even if they've done something wrong, will want to talk to the police and say they didn't do it. You have the right to remain silent. But if you choose not to exercise that right, you don't have the right to lie. And oftentimes, unfortunately, making a misstatement of fact, whether it's intentionally or accidentally, is often used as evidence against you. And in talking to the police, it's good to assess what the police want to know and what they have. So having somebody with you, like who knows the value of what your statement may or may not be, will help you determine whether it's in your best interest to talk to the police or not, and make that decision. So a lot of times, unfortunately, we get involved because people have been accused, and we find out that they've made statements to the police thinking that they were exculpatory, meaning they didn't do anything wrong, but in the course of that statement, they made admissions that would be used against them, not knowing perhaps what the police had, or even if they were mistaken about something, that ends up being, they want to correct that misstatement. Then all of a sudden it becomes you're making that up and you're lying, you're changing your story. Look, a lot of times I have clients and we make the decision to talk to the police, but it's only after a careful consideration of what information they have, what the police want to know, and whether or not it's in the client's best interest to make that statement.
And what some people don't take into consideration when the police interview and interrogate people, they can lie to them.
The police don't have to be truthful.
The police don't have to be truthful with people when they're asking them questions about criminal conduct. And in fact, the appeals courts have upheld that the police have the right to lie to people when they're talking to them.
They could tell them, we have evidence, this person said you did it, or we have your fingerprints on the gun. They could tell them that even though it's not true.
That's correct.
They can come in with a binder that looks like they have a whole ton of evidence. And matter of fact, they're all blank pages.
We have all the evidence to convict you. It'll be in your favor to tell us what happened.
I usually laugh because I say, if the police say to you, we can do this the easy way or the hard way. The easy way is you make a statement that is an admission, and that's easy for me. Or the hard way is you don't say anything and you get your attorney involved, and then it's going to be harder for me to prove you guilty of any offense.